We'll see tomorrow.
Lordship.
Not today. All
Principal seat case matter, bail application 22855 of 2026.
My lord, one of my RSA 224/2012 was dismissed for default of lawyer, that means he did not appear. So, my lord, it may kindly, I have filed an MC for registration of the said RSA. So it may can be listed when, I don't know when your also will come. On that day, I will fix it.
It was dismissed for default.
Dismissed for default, yes. It may be, I have mentioned it for day after tomorrow, but it was subject to a lawsuit
What is it?
convenience.
Is it related to this item? Huh?
No, my lord, I am appearing in this item, my lord. He is making a mention, my lord.
I am making a mention, an RSA which was dismissed for non-prosecution of lawyers of the appeal. So it was dismissed. I have filed an MC for registration of the said RSA. So I prayed that it should be listed on 26th, subject to your lordship's convenience.
No, tomorrow we are not having a single bench probably, and day after is a holiday. So, Thursday.
Thursday, highly honest.
Yes.
My lord, my lord, petitioner, my lord, he is behind the bar for now 92 days. And earlier it was rejected by your lordship, and it seems in the meantime charge sheet is already submitted. So lordship now, for the purpose of investigation, he is not required. All what remains is the trial. So lordship, he will appear on each and every date. He will cooperate with the trial. So lordship, he may be allowed to go on bail because already 92 days, and now his only purpose of detention will be to secure his presence during trial. That can be done, lordship, by any condition imposed by this honorable court.
My lord, in this matter, my lord, city was called for, my lord. So we gave them, my lord, that is intimation that, my lord, in the meantime, my lord, charge sheet has submitted on 19/8/2026. 1031 section is there, my lord.
All right, scan copy of TCR. When?
Now, lordship, lordship, I'll pray for a short date if possible.
Yes, PP.
My lord, scan this here, any day your lordship's convenient.
That will be in
Or we
Gauhati
can
only
do-
now, because we have only 3 working days here.
Lordship may also
Next
dispose
week.
of with a liberty to approach the learned trial court
All right, if that is what you want.
if
Then why
not
just
rejecting or dismissing it.
you can simply
so-
withdraw this then.
No, lordship, kindly there will be a direction. Since charge sheet is already submitted, lordship, we may be directed to approach the learned trial court below.
We cannot give you a direction to approach, we can give you liberty.
Liberty, lordship.
Hard learned counsel for the petitioner, who prays that liberty may be granted to approach the trial court since charge sheet has already been submitted. Full stop. Prayer is allowed. Petition stands closed accordingly.
I am grateful, madam.
For admission, item number 1.
My lord, the state respondents, the Deputy Commissioner Longklai has filed the affidavit. It's dated
What is the matter about?
My lord, the matter pertains to claiming of compensation in respect of construction of Kaladan Multimodal Transit Transport Project. And if your lordship may kindly see the order dated 8/6/2026 of this court's order, 8/6/2026. In pursuant to this order dated 8/6/2026.
So we are on draft award 1 of 2022.
Yes, my lord.
Yes, my lord. The state respondents had recently filed an affidavit clarifying the reasons for enhancing the award due to multiplication factor and due to the time of taking possession of the land in question. They have revised the award. They have clarified that in their affidavit, my lord. And the recent award was, the latest award was already approved, which I may place before your lords. The district collector had already prepared the award. The state had already.
So this was a poser from the court. Why was the enhancement
Yes,
made?
my
Yes,
lord.
my
I
lord.
have filed my affidavit.
That was not your case. Your case was pay me what has been enhanced. But the poser came from the court. Why it has been enhanced?
Yes, my lord.
Right.
So they have filed their affidavit.
Yes.
My lord, in my affidavit dated 5/8/2026, I have explained it, the reasons for the enhancement at page 3.
Okay, you have explained the reasons for enhancement. What about the payment part now?
So
My lord,
if direction be made for payment.
I think there was some order for making the forest department a party.
yes, my lord. I have also sent a letter, communication letter to the forest department. Till date, no news, my lord, from the department. So it can be presumed they are not interested. My lord.
And after that, my lord, this court on 6/8/2026.
Your affidavit is dated?
It's
5/8.
5/8/2026.
Filed on 13/8. Is it? Affidavit by respondent number 5?
Yes, my lord, it's respondent number 5. In my reports, it's filed on 5/8. Maybe it's.
Yes, so now who is to make the payment? Deputy
The-
Commissioner.
Ministry of Road Transport and Highways are supposed to make sanction of the fund. They were also included as a party.
My Lord,
herein.
I am for respondent number 1. I was not furnished a copy of affidavit filed by the state government.
My Lord, will furnish them today, Madam.
No, that you are not upon on that. Nobody is saying it should not be enhanced. It was just a question from the court. He is here for the approval part. What is your stand on that? It has to be sanctioned, isn't it?
Yes, my lord.
So when was the letter of the
My lord,
revised amount draft award 1 of 22 cent? At least in the year 2022,
my
is it
lord,
not?
I have furnished the recently My lord, that communication letter dated on the second page, my lord. Kindly see the second page of the letter which I am furnishing.
So government has approved.
Yes, my lord. Kindly see the second page, letter dated 25th March 2026. This is government approval conveying to the district collector.
Yes, so now the superintending engineer is to deposit it into the bank account.
The PWD superintendent engineer has to raise for sanction from the Ministry of Road Transport and Highways. They have to submit this.
So after government has approved, he again has to take sanction.
Yes, my lord. The fund is not yet sanctioned.
That is administrative sanction or finance department sanction? Now who is to answer?
The project is under the Ministry of Road Transport and Highways.
Hmm.
And this approved award has to be furnished to the Ministry of Road Transport and Highways, who will be the acquiring authority.
So this is dated 1st of April 26.
Yes, Your Lordship.
So nothing has happened after that.
I am not aware of the present status after this, my lord.
My Lord, let me inquire upon the present status of this case.
Heard learned counsel for the petitioner and learned additional AG. Yes. Also heard. You are for?
Respondent number 8.
Respondent number 8. Learned counsel for the petitioner has furnished a copy of the letter dated 010426 addressed by the Deputy Commissioner Longklai to the Superintending Engineer PWD Multi-Nodal Project Division Southern Circle Longklai, conveying the government's approval for draft award number 1 of 2026 amounting to rupees 2716849,847 for the construction of Kaladan multinodal transit transport project within bracket KMMTP. Full stop by the said communication. The PWD was asked to deposit the aforesaid amount in the account of the multinodal transport project. Along with the said letter, the approval of the government as dated 25/3/2026 as conveyed to the district collector by the Land Revenue and Settlement Department has also been enclosed. Full stop. Learned additional AG seeks some time to obtain instructions as regards the present status. Full stop. Further, an affidavit has been filed on behalf of the respondent number 5 in compliance of this court's order dated 08/06/2026, wherein the detailed calculation leading to the enhancement of the awarded amount has been shown. Full stop. Raise the matter again on when
Next week, my lord, maybe
31st, Monday.
my lord, 3rd of September.
3rd of September, on which date the necessary instructions will be furnished.
Much obliged.
Item number 2.
Your Lordship, in this matter, I'm appearing on behalf of my senior, who is for the petitioner. Lordship, my senior, Mr. Sijaram Sani, is on lag, so I kindly seek your permission if this matter may come after 1 week.
Seems you have not taken steps. Who is appearing for the respondents?
For respondent number 1, my lord.
Huh?
State is also party.
For respondent number 1.
Number?
1.
Only one.
State is 4 and 5, madam.
4 and 5. But it says notices to respondent 3 and 4 have returned unserved with postal remark. RTS, who is 4?
I think it's only 5. Respondent 5 is the state. 4 is private respondent. Four is the chief manager, Mizoram Rural Bank.
Four is proprietor of some enterprise.
Private respondent.
Director land revenue is 5. Wakalatnama is submitted for 2 and 3, but none appears, it seems. Yes, what was your submission? Your senior is not here.
Yes, he's on leg, my lord.
If he is on legs, he can come. But you have not taken steps. Fact remains that.
Your lordship, I'm not aware of the facts of the case, so if my
Steps around.
All right. Prayer is made on behalf of, what's his name?
Isaac Laramrota.
For adjournment. Learned Miss Linda, learned AAG appears for respondent number 5, and learned counsel Mr. Stephen
Yes, my lord.
appears for respondent number 1. None appears for 2 and 3. Although Wakalatnama has been filed. Pursuant to order dated 28/07/26, petitioner was required to take fresh steps on respondents number 3 and 4 after obtaining their correct address, but no such steps have been taken. Place the matter again next week. Okay.
Right.
Item number 3.
Your Lordship, this criminal petition is to challenge the order passed by the Special Court Prevention of Corruption Act at the time of opening of the case. The reason why we are aggrieved with is that, Your Lordship, at the time of opening of the case, an order was passed by directly saying that the learned trial court stated that he finds a prima facie case to frame the charge, but without conducting any hearing under Section 250, there is opportunity of being heard. There is the main reason why we are aggrieved to it. Because, Your Lordship, the reason why we are aggrieved to it is that if, at the same time, Your Lordship, I would like to submit that we also filed the discharge application after case was opened, prosecution case was opened. And now it is to be heard. And if discharge application is heard, then that or the impugn order already passed may have an influence, because he said that the learned trial court said that prima facie case was already found. That is why we are here, Your Lordship.
When was the discharge application filed? After
Discharge-
passing of the impugned order?
Yes, Your Lordship. It was filed on 17/7/2026 with the stipulated period of 60 days. We were still having 60 days at that time.
But before that, this impugned order was passed?
Yes.
Before expiry of the 60 days?
Yes.
Where is the impugned order?
Impugn order is at page A, my lord. There is the index, next to the index, Your Lordship. Alphabetical A.
This 24/6/26.
Yes, Your Lordship. The relevant portions, yes. It starts from third para. Today is fixed for opening of the case.
So what happened on 29/7? Stay.
Yes, it was adjourned and tomorrow is fixed for taking up the matter again.
So this 60 days was not over.
Not over yet, Your Lordship. Still 2 days remaining at that time.
But that is what you should have stated when the matter was taken up for charge hearing.
It was
You were
not
going
yet
to file the charge application. You appeared, participated in the charge hearing. You made your submissions. After
Sir-
that, this order has come.
Charge is not yet framed, Your Lordship.
May not be framed, but do you have a right to file discharge application now after you have been heard?
But that hearing was not
Discharge
under,
application was not mandatory.
my lord, the hearing was not under section 250. It was at the time of prosecution, opening of the prosecution case. So what we are saying is that 249 was, yes, complied with, BNSS, but 250 was skipped. And thereafter directly saying that there is a prima facie case. We were not heard under 250. That is our point. And
These are stages. It doesn't mean at a separate date. Today is for opening of prosecution case. Tomorrow is for charge. If in the opening of the prosecution case you participate, then what is the difficulty in framing the charge?
Your Lordship,
You were aware that charge was being considered.
and Your Lordship, at the same time, our discharge application was admitted and it is to be heard now. Now it is still pending. So what we are afraid of is that if it is heard, that a discharge application is heard, but if it is heard, the impugn order will have an influence because it had already stated that prima facie case was found. So if that can be taken care of, so Your Lordship, while submitting
This after you filed this discharge application, has any order been passed
not yet.
for hearing of that application?
Yes. Or after filing of the discharge application, the date was fixed for hearing of the discharge application separately. It was taken up separately, my lord. But what we are concerning is that this impugn order, which says that prima facie case was found, that will have an influence even if discharge application is taken up for hearing, my lord. The stipulated period was still there.
So you are also not opposing the hearing of the discharge application.
We are not opposing the discharge hearing, my lord.
Yes.
In fact, this order challenged by the petitioner deserves to be dismissed for the fact that on 24/6/2027, they were present and they were heard, and they have a mere apprehension that a finding recorded by the learned special judge prima facie would be to their disadvantage, my lord. As your lordship knows, the prima facie is not a record of conviction or innocence. The prima facie finding can be recorded by the learned trial court at any stage of the proceedings. Now, if I may kindly bring to your lordship kind attention is that when the impugn order was passed, no discharge application was filed. It was only filed on 17/7/2026. And now the learned trial court was pleased to fix the discharge hearing on 27/7/26.
That is what we are saying, that opening, okay, it was the stage of opening of the prosecution case, but then the defense also participated and
Yes,
opposed it.
correct. Your lordship
So
observation
effectively,
is-
they participated in a charge hearing.
yes. And there is no
After
but.
the order having gone against them, now they have filed a discharge application. But interestingly, you do not oppose that, and the court has also fixed a date for hearing of the discharge application, while
No.
the present impugned order also stands.
Yes, my lord.
So if the present impugned order stands, can he give a finding that there is no material is discharged?
No. My lord, may I make a submission on that? A
Yes.
prima facie finding is not a record of conviction or innocence. Court can record any prima facie finding at any stage of the proceedings. This prima facie finding, which is recorded by the learned trial court, does not bar the learned trial court to have a different finding at the time of discharge hearing. Now, the learned trial court had fixed the date of discharge hearing on 27/7/26. So, the learned trial court did not foreclose the petitioner on hearing the discharge application on merit. If I may go further, my lord, even if a charge is framed, that charge would not mean that there is a record of conviction or innocence. There's almost Supreme Court ruling on that also. Now, here is a case where they have a mere apprehension that the prima facie recording would have an adverse effect on their discharge application. For the simple reason that on 24/6/26, when the impugned order was passed, there was no discharge application.
No, there is a larger question involved.
Yes, my lord. Now, here in this case, they have stated that 60 days period was still there. Now, as per Section 5 of the Prevention of Corruption Act, trial of warrant case before a magistrate has to be followed by the Learned Special Judge PC Act. We have raised already in our written objection against their discharge application. Now, on the face of it, this impugned order deserves to be dismissed, and their discharge application will be taken up by the learned trial court. A mere apprehension will not do, my lord, in this case.
Your Lordship, if I may, my Lord. Once there is a decision for framing of charge, there cannot be a question of discharging the present petitioner from the charges leveled against him. So, this is the main reason why we are challenging this impugned order, which directly says that prima facie case was found. It was, in fact, found prematurely without going to bypassing that section 250 BNSS, because we were heard. We were not yet heard under section 250 BNSS. At the time of opening of the case, I understand what your Lordship said. On the same day also hearing can be done, but it was simply recorded as if we were heard. But it was at the time of opening of the case under section 249. And 250 was skipped and directly saying that prima facie case was found. Because if we read
All right, we can dispose of by saying that the discharge application will be decided on merit.
Yeah,
Yes.
correct.
On merit.
Now,
yes,
if your
and
lordship-
this impugned order may not have any bearing, may not have
Yes,
any influence.
all
Yes, my lord, that can be.
He is also conceding that disorder will not influence
Yes, yes.
anything.
Lordship
That
may
will be
kindly
fine, my
come to page 10 of my written objection. Page 10.
Then that will serve our purpose, my lord.
Here, this is the date when the discharge application was proposed to be taken up. Now, both parties are present through their respective counsel. Today is fixed for hearing. However, court is adjourned as prayed by applicant counsel for them to give them the opportunity to file an appeal against the impugned order 24/6/26. That means they were heard and they will be heard on the discharge application as well. So
Yes, nobody is disputing that. They will
Nobody
be
is
heard.
disputing. So this impugned order challenged by the petitioner may be dismissed with an observation made by your lordship that it will not influence the learned trial judge.
Well, leave the choice of words for us.
I'm sorry.
He has heard learned counsel for the petitioner and learned Mr. So-and-so. You are appearing for whom?
I appeal for the Mizoram Lokayukta,
Respondent one.
respondent number 2.
Respondent number 2, Mizoram Lokayukta.
My lord, interestingly, the state has come up before this court as a respondent. However, they were not a party. They were not made a party in the trial court. So that is the question.
Maybe he was hoping that they would support him.
Let my learned friends say something if they are going to support them or not.
Anyway, let's not entangle ourselves in on that. You go to order dated 06/08/26, okay? First, para 1, 2, 3. Four. It is at the end of para 4, and the next date is fixed on when? Tomorrow.
Yes, my lord.
This code by order dated 6/8/2026 had stayed further proceedings before the learned trial court. Till the next date of listing. Full stop. An objection has been submitted on behalf of the respondent number 2. From the above, it appears that although the parties were heard are said to be heard on the question of charge as reflected in the impugned order, no charge has yet been framed, and it also appears that no final decision as regards the penal provisions under which the charge is to be framed has been taken by the learned trial court. And after filing of the discharge application on behalf of the petitioner, the matter has been fixed for consideration of the said application. Para learned counsel for the respondent number 2 submits that since the learned trial court has fixed the date for consideration of the discharge application, the learned trial court may decide the same on merits. Full stop. Para, it appears that that since no final decision on the framing of charge has been taken, despite recording of a prima facie satisfaction in the impugned order, there appears to be no impediment in taking up the discharge application filed by the petitioner on merits. Full stop. Accordingly, and as agreed to, full stop, this instant petition is disposed of with the direction to the learned trial court to decide the discharge application filed by the petitioner after hearing the parties, on merits after hearing the parties, and without regard to the impugned order passed by the learned trial court. Full stop. Petition stands closed accordingly.
My lord, I have one prayer. In this case, whether the learned trial court should follow 250 BNSS or 262 is another question.
That is a question you posed to the
Yes,
trial
my
court.
lord.
There is another question here.
We have submitted a written objection, my lord.
Much obliged.
Please, Your Lordship. My lord,
Item number 4.
similar order may be passed, my lord. Same charge sheet.
Okay. Different petitioner.
Different.
my lord.
I'm accused number
Different
6
All right. Same order.
in item 5 as well, my lord.
And
5 as well.
5 also.
Deeply obliged.
Obliged.
Item number 6.
May I plead, Your Lordship? Lordship, here in this case, Lordship, the petitioner was arrested on Lordship 9/4/2026. And Lordship, as on today, Lordship, he is in custody for 137 days. And Lordship, the forwarding report that will find Annexure 3, Lordship, will find page 27, Lordship. Page 27, Lordship. Here in this case, Lordship, the petitioner was Without Lordship serving the notice under 48 and 36 and 47 Lordship, the petitioner produced before the learned magistrate Lordship. Lordship, page 27 Lordship will find forwarding report.
Just a moment.
Paragraph 1 Lordship, the background of the case.
Page
Lordship,
27.
Page 27, Annexure 3 Lordship.
Huh?
Forwarding report.
Annexure?
3 Lordship.
Yes.
Forwarding report of the petitioner Lordship, and paragraph 1 Lordship will find the Lordship contraband was recovered on 6/3/2025, and petitioner was arrested after about Lordship, near about Lordship 1 year, after about 1 year Lordship, and may I read Lordship paragraph 1 Lordship?
You are Lalming Sangha.
Yes, Lordship. And the contraband was recovered from the Lordship here name, date and for 5
In
persons.
first
Lordship.
para 1, your name is not there.
Lordship, my name is not there, Lordship, and he was arrested after 11 months, Lordship. On 6/3/25, Lordship, 5 persons were arrested, and from them, Lordship, 48.061 kg of methamphetamine were recovered.
Yes.
And Lordship, as per my information, Lordship, and they are already on bail, Lordship. And my implication, Lordship, will find paragraph, Lordship, page 12, Lordship, page 42, Lordship, paragraph 12, Lordship. The continuation of forwarding report, Lordship. Page 12, Lordship. On 9/4/2026, Lordship, the NCB issued 67 notice, Lordship. And accordingly, on the same day, Lordship, he appeared, Lordship. Paragraph 13, Lordship. Page 43, Lordship. Paragraph 15, Lordship. On the basis of confessional statement, prima facie evidence of corroborative statement, Lamilhunga was arrested on the same day, that is on 10/4/2026, after about 11 months, Lordship. And Lordship, he was arrested only on the basis of statement of the co-accused, Lordship. And he was Lordship, here in this case, Lordship, the section 37 notice that will find page 49, Lordship. In 36 notice, Lordship, there is does not bear the attestation of independent witness of family members, Lordship, in the 36 notice, Lordship.
Page?
Page 49, Lordship.
Okay, what are your grounds? 36?
36, 47, Lordship, 47 not properly served, and Lordship 48, Lordship. The 48 notice served through registered post, Lordship.
36 is which page?
Page 49, Lordship. There is no signature of any family member or any local persons, Lordship, respectable persons of their locality, Lordship. And Lordship, 47 notice will find page 54, Lordship. Lordship, in 47 notice, Lordship, there is merely, Lordship, narrates the case number and statutory provisions, Lordship. And in 47 notice, Lordship, without disclosing any, Lordship, specific rule and Lordship, overt act, Lordship, or Lordship, actual basis, Lordship, for connecting
Just a moment, what was the page number?
page
47 notice?
54, Lordship, page 54, Annexure 9, Lordship. May I read,
Where
Lordship?
is PP?
Your Lordship, in this matter, I'm appearing on behalf of my senior. We have filed our affidavit in opposition today itself.
Where is that?
In the first hour, it's still in the registry.
This is what, NCB?
Yeah.
NCB, Lordship. Initially, it was Lordship, subsequently it was transferred to NCB, Lordship.
So anybody appearing for NCB? Other, besides you?
No, Your Lordship.
Lordship, there is absolute violation of section 36 and 48, Lordship. And other five accused
You have got
already on
copy of
bail.
their affidavit?
No, Lordship.
So, what to do? Would you like to proceed without perusing the affidavit?
Lordship, Lordship.
Huh?
Lordship. Lordship may heard on merit, Lordship.
Your Lordship, if this matter may come after 1 week.
No, we may hear on merit, but we will consider the affidavit. Then you won't have a chance to object to that if anything is there. Then you leave it. You will have to leave it to us completely. Then.
Lordship.
So what do you want to do?
Lordship, apparently, Lordship, on the record, Lordship, there is absolute violation of section 48 and 47, Lordship.
No.
And the
Before we
honorable
go
apex-
into that, we don't know what is there in their affidavit. If you want to take a risk, that's it. Yes. What again? You are submitting something.
No. Your Lordship, we can serve their copy anytime. So, if
Anybody appears? Who appears for NCB here? Anybody?
Your Lordship, I'm for the NCB side, Mr. Sisaram Chana. No one appears on me other than that.
No, he is standing counsel, retainer counsel for NCB.
Yes, sir. Special PP, yeah.
Special
Your Lordship.
PP for NCB.
Yes, Your Lordship.
So you are making any prayer on his behalf? Is it?
Yes, Your Lordship.
What is that prayer?
He's on lack on the court number 1.
That is not a prayer. That is an information.
Your Lordship, I'm not aware with the facts of the case, so
Or Lordship may take as a last item, Lordship.
I'm praying for 1 week
in
time.
the
Your
meantime,
Lordship.
Lordship, his senior will arrive, Lordship.
Okay, let's wait for some time. You ask him to come.
Yes, Your Lordship.
Deeply obliged, Lordship.
Item number 7.
My lord, this is a bail application under 483 BNSS, and on the last court date, a scanned copy of the trial court report was called.
I don't think it's there. Item 7,
Yes, item 7. Lord.
not mentioned in the cause list. PCR is there. Yes, what is your submission?
My lord, basically, my ground in this bail application is non-compliance of section 48, my lord.
48.
Yes, my lord. Main ground, my lord. Relatives of the accused are not intimated in writing, my lord. And
Is it a case of no notice or defective notice?
no notice at all.
No
48.
notice.
Yes, under 48, my lord. And my lord, co-accused in this, co-accused has been released by this honorable court. And bail order is in page 43 of my application, my lord, wherein the co-accused has been granted bail. For
40?
the same, 43, my lord. The relevant part is in paragraph number 9, my lord, which is in page 46 of the bail application, my lord. Page 46.
Both of you were arrested on the same date,
Yes, same date, same ground,
same time.
same time, yes, my lord. Though notice under 47 has been given to us, but not under 48, my lord.
Yes, PP, same footing.
My lord, it seems so. I've checked the reports. I could not find the section 48. And seeing from the seizure and arrest memo, my lord, it seems from the seizure and arrest memo at page 23 of the petition, my lord.
Yes.
23.
20?
23.
Page 3.
2-3.
2-3.
Yes. Seizure and arrest memo. And the relevant portion is at page 24. 2-4. Lordship has got page 24, the second paragraph. Intimation of seizure and arrest were given to their families by a phone call. That is the accused number 2, 3, and 4. Accused number 1 was given to the wife on the spot. So, my lord, it may be true. The submission of the learned counsel may be true. I could not find it in the records either.
All right. Go to page 43, okay? First para, second para. Third para. Fourth para. Fifth para also. Sixth para also. Learned PP, upon perusal of the record, has fairly submitted that no arrest, notice under section 48 BNSS is available therein. Full stop. Although learned PP has referred to the arrest memo, wherein it is stated that this is accused number?
Case number 2, my lord.
Number
3.
Yes.
That the intimation regarding seizure and arrest was given to the family of the petitioner by a phone call, comma, it is settled law that the same does not amount to compliance with section 48 BNSS. Full stop. Having regard to the above and the fact that similarly situated accused persons have been granted bail as aforesaid. The prayer for bail is allowed. Accordingly, and it is directed that the petitioner shall be released on bail on the following conditions. Subpara 1, 2, 3, 4 of para 11, page 47. Okay.
Unobliged, my lord.
Item number 8.
Yes, may please, Your Lordship. I'm here for the appellants. And Lordship, kindly grant us another 2 weeks' time to file the additional affidavit, Lordship.
All right, as prayed for by learned counsel for the applicant. For 2 weeks further time is granted to file the additional affidavit. So and so is present for the
Responding.
sole respondent.
2 to 5, Your Lordship.
2 to 5. List again on
10th of September.
Obliged, my Lord.
Item number 9.
May I please, Your Lordship?
the
Uh,
one that item we have passed over. The additional affidavit call for it. Opposition, objection. I think they have. Yes.
My Lord, in this case, Your Lordship has granted us release of the seized currency in a criminal petition we had filed before with the execution of bank guarantee. However, my Lord, we have approached the bank. They are reluctant to give us any bank guarantee unless and until we deposited the same amount as term deposit. Then, my Lord, we do not have money to run a business, and that's why we apply for this release of the seized currency. And my Lord, the bank are saying that for that, the bank guarantee has to be in the same amount. It has to be deposited. My Lord, if I may take Your Lordship to page number 19, Annexure 3. These are the letters issued by the bank.
Yes, pardon.
Yes, my Lord, at page, if I may take Your Lordship to annexure number 3 at page 19 of my application.
So, what condition can we put?
My Lord, we had asked for a Zima bond, indemnity bond, maybe executed if we had submitted Your Lordship's order, and with regard to that, the trial court had passed an order at annexure 2, page 16. My lord, the operative portion is at page 17, para 2.
Yes.
Pursuant to the order directing the release of the seized amount, the following terms and conditions shall govern such release. Number one, the applicant shall furnish an unconditional and irrevocable bank guarantee issued by nationalized or scheduled bank for an amount equivalent to the seized money. My lord, it's like saying that you cannot release, it's like prohibited to be released. Even then, we had approached the bank to consider our land passes. However, the land passes were out of ISOL and it cannot be considered for the purpose of bank guarantee, for issuance of bank guarantee. That, my lord, that is written in the last paragraph of the bank letter, annexure number 3 at page 19. If I may read. It is further to be mentioned that land and building is required for collateral security. No vacant land or land located at far-flung area cannot be accepted as collateral security. Your house pass is located at far-flung area and cannot be accepted as collateral security. So the banks are demanding, and also as per the order of the trial court, to deposit amount of the seized currency.
Because you said that you will offer bank guarantee.
Yes, my lord, but
That was
however,
reflected in the order itself. Because
Yes.
you said you'll give bank guarantee.
yes, my lord, bank guarantee is not that difficult. However, the trial court had set a very difficult conditions again.
What
That-
difficult?
That, my lord, at page 17, para number 2.
Yes.
Pursuant to the order directing release of the seized amount, the following terms and conditions shall govern such release. Number one, the applicant shall furnish an unconditional and irrevocable bank guarantee issued by a nationalized scheduled bank for an amount equivalent to the seized money. Tamalo, for this, then the same amount has to be deposited as term deposit.
So this is the High Court's order, willing to offer bank guarantee for an amount corresponding to the value of the currency notes. That was in the High Court order.
But my lord, when we approached the bank, then they were saying that it has to be deposited and our immovable property cannot be considered.
Yes, PP, what to do now?
My lord, in the High Court order which is passed by your lordship, it doesn't specify the amount of the suitable bank account.
Your Lordship,
Yes.
Your Lordship, my learned friend can correct me if I'm wrong, but from the documents itself here, it can be seen that they have approached the head office, MRB. However, there is Champhai branch, Mizoram Rural Bank, and there are several branch in bank in Champhai district like SBI, HDFC, so, such and such. If they have a property there, they should have approached the Champhai branch for the security. Obviously, if they have approached the main office as collateral security, then they will obviously issue the page number 19, the letter. So there is nothing to show that they have approached Champhai branch of any bank. And Your Lordship, it is on their own submission and their own willingness that this honorable court was pleased to grant them.
Where is the property located?
Champhai.
They are at Champhai,
And which bank did you approach?
rural bank.
Head office at Aizol.
My lord, we approached Champhai and they told us that the bank guarantee are issued at the main office only, which is at Aizol, at the capital. So the Champhai area cannot give the bank guarantee.
That may be because they have their Mizoram Rural Bank. But other bank may give.
Yeah.
My lord, the other banks also, they have approached the SBI as well. However, they said that it has to be deposited.
How much can you deposit?
My lord, our prayer is that if we deposit 1 lakh,
1 lakh
yes, my lord.
out of 24 lakhs.
My lord,
The very fact that 24 lakhs was recovered from you, which you claim to be legitimate for the purpose of payment, you are in the food business, shows that you are capable of paying much more than that, more than 1 lakh.
my lord, if any amount your lordship thinks fits and proper.
You better get an instruction because at least this is 24 lakhs. Even if we reduce it by 50%, it will be 12, about 13 lakhs. Better get your instruction. Otherwise, again, you will come and say this is too high, this is so.
My lord, can it be like 5 lakhs?
I don't think so. You are not the client, you cannot say. You have to take the instruction from the client.
Yes, my lord. I'll ask. My lord, if it may be passed over for a while, if it may be passed over for a while.
For a while.
Yes, my lord. I'll just make a call.
All right. 50%. Yes.
Item number 10.
Yes.
Lordship, this
Commercial.
is... yes, sir.
Charge sheeted or under investigation? Is it charge sheeted?
Non-charge sheet.
Huh?
Non-charge sheet.
Not.
Yes, non-charge sheet.
Okay, CD then. Heard learned counsel for the petition and additional PP. This is an application under so and so.
May I please, Your Lordship, may this matter may kindly be fixed on this coming Thursday.
It will come so quickly.
Your Lordship,
It is so commercial quantity. What is your date of arrest?
19, Your Lordship.
Huh?
19/4/2026.
Oh, so what is the hearing hurry?
Since he has
Thursday, we are
been
not fixing
incarcerated,
so many cases.
So
Let it,
100
let it
Yes,
come
Your
on.
Lordship. Next week, if possible, next week.
All right, next week, give a date. Next Tuesday?
Okay,
Yes, on the
1st of September.
All right.
Item 11.
May it please your lordship.
Yes.
Lordship, petitioners were behind the bar for 84 days, lordship. Let the CD may be called for, lordship.
All right, same order.
Lordship, can it be on Thursday, lordship? It's from Aizol itself.
No, it can't be. It will be on Monday.
Okay, lordship.
Item number 12.
My lord, although the counsel for the applicant, David Malsomkima, is not my senior, I was requested by him to seek for adjournment as he's unable to present today because of his ailment.
This is only for impleading the DC. Why do you want an adjournment for that?
Yes, Your Lordship. However, the main counsel is not present today.
But she has argued very well.
No, my lord, I'm not his junior, my lord. I was just requested by him to seek for adjournment.
What is the point of delaying these matters? You want a stay of the order passed by the deputy commissioner who has not been implemented.
Yes, Your
and
Lordship.
filed an implement application. Allowed. We'll dispose of this. But this is an application for implement of the deputy commissioner Aizol as a party respondent, inasmuch as he is the authority that issued the impugned order dated 24/06/26, which is challenged in the connected writ petition. Having regard to the averments, the prayer is allowed. The deputy commissioner Aizol is implemented as respondent number. We see the respondents, okay, last after that. Amended cause title to be filed, list again after a week. I extends disposed of.
For pass of our item. Item number 6.
Item number 6.
Has he come?
May please, your lordship. Lordship, I have received the objection copy, lordship.
Yes.
Lordship. Lordship, 36 rupees, that will find lordship page 49, lordship.
Page?
Page 49, Lordship.
Of the objection.
No, Lordship, in the petition, Lordship.
No, yeah, what have they said in their objection?
Lordship. Objection, Lordship, then may I please, Lordship, the objection, Lordship. Paragraph 9, Lordship, they stated about, Lordship, paragraph 8, Lordship, page 6. They are affidavit, Lordship. In paragraph 8, Lordship, they stated that the abarments made in paragraph 9 of bail application are false, misleading and denied. The arrest of accused was lawful and strict compliance with provision of BNSS. The arrest memo was prepared contemporaneously at the time of arrest, and the accused was informed of the grounds of arrest, and all statutory safeguards were duly observed. The accused was arrested on 10/4 and exercise. The family member of the accused were residing in Gauhati, which is situated at the considerable distance from the place of arrest. So, Lordship, they admitted that, Lordship, at the time of arrest, his family members was not there, Lordship. They itself stated that, Lordship, the family member of the accused were residing at Gauhati, Mizoram, which is situated at considerable distance from the place of arrest. Owing the distance and transport constraint, the urgency of the arrest, it was not practically possible to secure the physical presence or attestation of any family member on the arrest memo. So they admitted that, Lordship, the family member was not there, Lordship. Immediately after arrest, the investigating officer informed the wife of the petitioner, of the accused, over his mobile phone regarding the arrest and place, detention and investigating agency.
I think we have to hear.
Lordship. And Lordship, 48, regarding 48, Lordship, they stated in the paragraph 9, Lordship. The prosecution never claimed that speed post was the first or only mode of communication regarding. And Lordship, the speed post, it was posted after 14 days, Lordship, and it was received after 18 days, Lordship, of his arrest. I have enclosed the, Lordship, postal tracking report as well as, Lordship, the envelope, Lordship. That will find, Lordship, page. They specifically stated that, Lordship, immediately after arrest, the applicant wife was informed telephonically, and that written communication was subsequently sent by speed post, Lordship. But, Lordship, this section 48 requires the, Lordship, arresting authority to forthwith give information regarding the arrest and place where arrested person is being held, Lordship. In the, Lordship, the respondent, Lordship, where they cannot rely upon a subsequent written communication to, Lordship, retrospectively, Lordship, to cure a failure to comply the statutory requirement at the relevant time, Lordship. whether the Lordship, the statutory safeguard were complied within the manner and within the Lordship, section 48 or not, Lordship.
All right,
May I please, Your Lordship,
Lordship,
actually.
may I place some judgments, Lordship?
Apologies, my senior is still on legs in court number 1, that's why he cannot appear today. Lordship, as one of our junior had submitted earlier, we have filed our affidavit in opposition.
Yes,
and
it
I
is
have
before
sent
us.
a soft copy to one of the advocates. I think she has
He has
forwarded-
already got it.
Yeah, so, Lordship.
I have received, Lordship.
Okay. So we seek 1 week time for
For what?
hearing, my lord, because my senior is still on legs in court number 1, and we have 2 other matters today, so.
Lordship, may I place 3 judgments, Lordship?
No, let us first decide whether to go ahead or not.
Okay, Lordship.
We don't want to do that again and again.
Lordship. He is in custody, Lordship.
Right. He is in custody. He has been in custody for quite some time. So
Lordship.
it's not as if.
And other 5 accused already got bail, Lordship, due to non-compliance of that provision.
Where is that?
Lordship, order is not there, but Lordship, I have submitted one status report, Lordship, case status from the website, Lordship, where it is written, Lordship. My colleague submitted in the courtmaster, Lordship. May I, Lordship, kindly see, Lordship. It was collected from Lordship website of e-courts, Lordship, from District Court Aizawl, Lordship. Here, Lordship, in second page, Lordship, there is 6 persons, Lordship. In second page, Lordship, 1, 2, 3, 4, 5. I am for 6, Lordship. And Lordship may directly come last page, Lordship. Last second page, Lordship. Last part second page, Lordship. Date 14/8/2026, Lordship. Here it is written, Lordship, A6. That is the petitioner, Lordship. In bottom, Lordship, A6 is produced from judicial custody. A1, A2, A3, and A5 on bail are present. A4 on bail is absent. Surety absent. No cause learned TI present. Personal attendance of accused is dispensed for this day to avoid undue delay. PW1 absent. Summons served and returned. No cause. PW4 examined and cross-examined on oath and discharge. A6
All
is
right,
remanded back to
we'll take this up on Thursday, first item.
Lordship.
You furnish the order also.
Lordship.
Whether you appear or not on that day, we'll dispose of this application.
Lordship. Deeply obliged, Lordship.
Item number 9.
My lord, I've just made a phone call, and then he said that it's very difficult as of now. 5 lakhs I can do it, but maybe if the court said maybe we'll have to find a way, and then he said like if it can come down to at least 8 lakhs, the least, if possible. He said that he needs some capital to run the business. Lord, I don't know if it's relevant or not, but if I just make one submission, because the bank guarantee has to be during the whole trial, and the trial is going very slow, and for almost 2 years, none of the witnesses have turned up so far. So we prayed for a dropping of the witnesses. However, it was not considered. So that is if the trial is going fast, then our chances of acquittal is also very good, in our opinion, in our humble opinion. So that is all right. However, my lord, that is the problem. If the bank guarantee amount is high, then the cut that the banks are taking are also again higher. So that is a problem. So my lord, if 5 lakhs deposit is not sufficient, my lord, if your lordship can please allow deposit of 8 lakhs. However, my lord, it's
Okay, we'll think about it. Let's
Yes,
see.
obliged.
For hearing, item 17.
May please your lordship.
Yes.
The appellant was convicted under section 22C and 25 of the NDNPS Act, and both under the sections, my lords, he was convicted for a period of 10 years and to pay a fine of rupees 1 lakh each, my lords. And then the appellant herein has challenged the impugned order dated 17/9/2025 and 23/9/2020, sentence order 23/9/2025, my lords. My lords, there is no written FIR in this case, my lords. So, with your lordship permission, if I may read page number 1, that is the information recorded, my lords, by the seizing officer.
Page number 1
Page
of?
number 1 of the paper book, my lords.
Yes.
Information recorded on 22/2/2021, self with party conducted random checking at Sing Langklang Junction, Zokata Road, and detained one vehicle Alto 800 car, BR number so and so, driven by Abdul Mukit. This is the appellant, my lord. Son of so and so, resident of so and so, on a suspicious ground. On checking of the said vehicle after preparing grounds of belief, we recovered black polythene containing 4 brown boxes containing 5 bundles. 1 bundle containing 10 black sachets and 1 sachet contains 200 small tablets, suspected to be methamphetamine. Total numbers 40,000 tablets. I seized the recovered items in the presence of reliable witnesses by preparing proper seizure memo. Seizure witnesses' statement is also recorded. The vehicle driver Abdul Mukit, son of so and so, and vehicle owner Abdul Hussein, son of so and so of Banda Kunda Karimganj, Assam, were apprehended for further necessary action. Kept the seized articles in NDNPS Malkhana. The 2 persons were brought to you along with the seized article after observing all necessary formalities at the spot, as empowered by the government of Mizoram, notification number so and so, date so and so, my lords. So, my lords, the owner of the vehicle, Abdul Hussein, was acquitted because he was arrested merely on the basis of the co-accused statement, Abdul Mukit, my lords. So, my lords, charge was framed, and the petitioner, the appellant, pleads not guilty and claimed for trial. And then the prosecution proposed as many as 5 witnesses, and then the accused appellant also had his evidence, my lords.
So what is the main ground of challenge here?
The main grounds of challenge is, my lords, the first one is section 42 of the NDNPS Act, my lords, violation.
Section?
42, subsection 2, my lords.
Yes.
If I may read, your lordship.
No, just say how it is violated.
Subsection 1, my lords. So, my lords, before conducting search, seizure, and arrest, he has to record information. He has to take down his information in writing and then send a copy thereof to his superior officer, my lords. However, in the instant case, my lords, his information was recorded only at 6:20 p.m. at the police station. After search, seizure, recovery, and arrest were already done, my lords. So he had clearly admitted in his cross-examination at page number 9, my lords. Page number 9, 7 para, my lords. The word starts with, it is a fact that my team detained the seized vehicle and they informed me through telephone and I proceed to the place of occurrence along with the civilian witnesses. I did not remember the exact time when my team informed me about the detained seized vehicle, from when the seized articles were recovered, but the sun was not set. It is a fact that I prepared my information in writing under Section 42(1) of the NDNPS Act at 6:20 p.m., which was after recovery of the seized articles, and there was no indication that my superior officer had received the above mentioned information in writing. My lords, after when he received information, my lords, he went to the officer in charge, my lords, first before going to the PO, and he obtained authorization, my lords. The authorization is at, my lords, at page 57, my lords.
But in your case, 42 may not be attracted. It is a chance recovery. 43 may be applicable.
No, my lords.
They did not have prior information. They were not acting on any prior information.
As per his cross-examination at my lords, at page number 9, at para 7, he received information from his team.
Page 9?
Yes, page 9.
Para?
Para 7, my lords,
Where is
cross-examination.
para 7 here?
Yes.
There is no 7. It is
para-
not numbered.
No, one from the second last, the two last para, my lords. So he received information
No,
from...
no, that is not information. That is information after he was detained. That is not
Yes.
information under 42(1).
Yes, his team already detained this vehicle.
Team detained this vehicle without receiving any prior information. It was a chance
No, my-
recovery.
no,
Section
my-
43 will be applicable.
And then his team informed him.
That is not information. That is information after recovery is no information.
No, there is no recovery. Only detained, my lords. So when he reached the PO, my lords, he conducted search and seizure.
Information is that such and such person is carrying such and such contraband. That information is to be written in writing, and the rest of the 42 will be applicable. This is just an information of detention.
Yes, if he, my lords, if he has received any information through phone call, my lords, that has to be taken down in writing.
That information has to be before the detention, not after detention.
So because, my lords, his team detained because of a suspicious ground, and then they informed him, my lord. And then the vehicle is a private vehicle, Alto car, which is owned by the co-accused Abdul Hussein. It's a private vehicle. And then, my lords, secondly, that information which he has taken down was not received or sent to his superior officer. It was not received at all.
Yes.
And my lords, by next ground is regarding section 52A violation, my lords. If I may read, my lords.
Yes.
52A subsection 2, where any narcotic, drugs, psychotropic substances, controlled substances, or conveyances has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53. The officer referred in subsection 1 shall prepare an inventory of such narcotic drugs, psychotropic substances, controlled substances, or conveyances, containing such details relating to their description, quality, quantity, mode of packing, marks, numbers, or such other identifying particles of the narcotic drugs, psychotropic substances, controlled substances, or conveyances, or the packing in which they are packed, country of origin, and other particulars as the officer referred to in subsection 1 may consider relevant to the identify of the narcotic drugs, psychotropic substances, controlled substances, or conveyances in any proceedings under this act, and make an application to any magistrate for the purpose of A. Certifying the correctness of inventory so prepared, or B. Taking in the presence of such magistrate photographs of such drugs, substance, or conveyances and certifying such photographs as true, or C. Allowing to draw representative sample of such drugs or substances in the presence of such magistrate and certifying the correctness of any list of samples so done. My lords, that why I'm raising this section 52A is that, my lords, if I may kindly take your lordship to page 66. My lords, here the list of sample drawn this is an exhibit. So the reference case is Champai PS case number 138 of 2020, my lords.
Page 66.
66, yes.
List of sample draw.
Yes, my lords.
Reference?
Reference Champai PS case number 138 of 2020. Date 12/12/2020. My lords, here in my case is Champai PS case number 8 of 2021. So there is no document or even the prosecution witness did not show that the samples was drawn in my case, in the present case. So it cannot be established that the suspected methamphetamine, which was allegedly recovered from my possession, was a contraband article. So that is my second submission, my lords.
Yes.
And my next submission is, my lords, regarding section 55, custody of the seized article and samples. Section 55, my lords. Police to take charge of articles seized and delivered. An officer in charge of the police station shall take charge of and keep in safe custody, pending the orders of the magistrate, all articles seized under this act within the local area of that police station, and which may be delivered to him, and shall allow any officer who may accompany such articles to the police station or who may be deputed for the purpose to affix his seal to such articles or to take samples of and from them, and all samples so taken shall also be sealed with the seal of the officer in charge of the police station. My lords, There is no document exhibited that the go down receipt, the go down in charge, which was issued by the go down in charge, is not exhibited at all. So it cannot be said that the articles, that contraband articles was being kept in custody during the trial, my lord. And as per section 55, my lords, the samples, the representative samples drawn shall also be sealed by the officer in charge. So no prosecution witness has stated that it was so sealed.
No Malkhana register was produced regarding safe deposit. What is the evidence you were referring to just now?
There is no evidence at all, my lords. So go down receipt was not exhibited at all, not produced.
Yes.
And my next submission is, my lords, regarding section 57 violation, my lords. So in this regard, my lords, if I may kindly take your lordship to page number 61.
Yes.
So, my lords, as per section 57, the report of arrest and seizure has to be submitted to the superior officer within 48 hours. But only, my lords, on perusal of page 61, the report of seizure and arrest. So the superior officer did not receive at all, my lords. It was merely exhibited at exhibited P4. So if it is received, it has to be countersigned.
No, why will there be counter signature of OC on this? This was shown, it was seen by the court earlier at that contemporary time.
Well, that the
He is not required to issue a receipt.
additional district and session just countersign it.
Yes.
But, well, lords, there is no time or date when it was received. It was not indicated, my lords.
There is no date of requirement of date of receipt. It was on date of 48 hours. He is to send it.
As
That
per-
date is there, 22 to 21.
As per section 57, it has to be submitted within 48 hours. So that is why I am raising this issue, my lord.
Yes, he has given the date. What more can he do?
So that, my lord, the officer whom he had addressed is the officer in charge, my lord. This is his superior officer, my lord.
Yes, so this is the report.
Yes.
Where is the requirement that he must give a receipt with date and time?
My lord, usually
It was shown to the magistrate.
they are the government officials, my lord. Every time when we submit a letter, so it has to be received and countersigned by the superior officer, my lord.
Where is the case diary? Is it available?
My lord, this case diary is not included in the paper book, my lord.
No, case diary will not be included in the paper book, but it should be. When records are called for, it should be sent separately. Must be there. Yes, okay, go to the next point.
My lord, next ground is non-production of the seized article during the trial, my lord. And it was not exhibited as material exhibit, my lord.
Which one?
Non-production of the seized article.
Yes.
Regarding non-production of this
Non-production of the seized articles.
My lord, my humble submission is in this regard is that, my lord, that this seized article is the court's property. Court's property. That the best evidence is production of the seized article, the primary evidence, my lord. However, my lord, if it is destroyed during that trial, there must be a destroyal certificate. There must be a destruction certificate issued by the Drug Disposal Committee. So, my lords, no prosecution witnesses, even the case IO, did not state where it is being kept.
Oh, if they comply with 52A and give the samples, that is to be treated as primary evidence.
My lords, as per section 52A, they did not apply, they did not submit any application to the concerned magistrate for destruction during the trial. There is no application at all, my lords.
There may not be an application for destruction, but even then, the section 52A makes the samples primary evidence.
But the samples, in my case, the sample was not drawn. That the case is
That is a
totally
different
different.
argument, but otherwise there is no necessity of producing the bulk if they comply with section 52 and produce the samples. Okay.
My next submission is regarding the contradiction of the place of recovery, my lords. As per PW1, PW1 and PW2, PW number 2, depose that in their examination in chief, my lords, the seized article was recovered, which was kept in between and the front and back seat inside the vehicle. But as per PW number 3 and PW
This is
number
between PW
1 and 2.
What did PW1 say?
PW1 says that the SA was recovered, which was kept in between the front and back seat.
And what did PW2 say?
PW2 also say the same, my lords.
Okay.
And but my lords, as per the deposition of PW number 3,
Yes, what did he say?
it was kept inside the bonnet cover of the between the front and rear seat. The bonnet cover is, my lords, with regard to the car, which is the front, which cover the engine.
What did he say? Where is PW3 page?
PW3 page 12, my lords.
Yes. Kept inside the
from
bonnet
8th
cover
line, my
of
lords.
the between the front and rear seat. The above. No, I think this was a mistake, typing mistake. It doesn't make sense.
And
It's not even grammatically correct.
PW
Kept inside the bonnet cover of the between the front and what is the meaning? Has no meaning at all.
Yes, there's no meaning at all. It was really confusing. PW5, the case I also said the same, my lords.
It's copy paste, it seems. Yes.
Lords, that is all my humble submission,
Yes,
my lords.
PP.
Well, lords, I have prepared a compilation of judgment, my lords.
All right.
So I have point out in the index, my lords, relevant page and paragraph, my lords.
All right. Fine. Give the case diary with the file also. Yes, PP.
Your Lordship, I have a little bit hard time in talking, so I will make my point very brief. With regards to section 52, Your Lordship, there is substantial compliance. Now, if I may take Your Lordship kind attention to
Yes. No, he has come to a very specific point that the case number is different.
the
He
case
hasn't
that I will explain, Your Lordship. If I may take Your Lordship to that page, in page
66, I think.
66. If I may take Your Lordship kind attention to page 65. Your Lordship, certification by magistrate under section 52A. Now, This case number and all is correct. Some 5 PS case number 8 of 2021. Now under the column, Your Lordship, marks and number. Your Lordship, marks and numbers column.
Yes.
Exhibit A1 to 5, Exhibit B1 to 5, Exhibit C1 to 5, Exhibit D1 to 55. Now, it was signed by the Chief Judicial Magistrate, which you can see, Your Lordship, at the bottom of the page, the signature, and signed 23/2, dated 23/2/2021. This is the signature of the Chief Judicial Magistrate. Now, I am not an expert, and this court is not an expert of the signature. However, Your Lordship, turning to next page, from a bare perusal of the comparison, Your Lordship, the signature of the Chief Judicial Magistrate is the same, and the date is same, 23/2. And the marking number, Your Lordship, Exhibit 1 to 5, B1 to 5, C1 to 5, D1 to 5. Now the reference, what I can explain at this stage, Your Lordship, is just a clerical mistake. And Your Lordship, when the case IO was examined before the learned trial court, all these things are exhibited in page number 16, Your Lordship. 15 is the examination of the case IO. And he was cross-examined. And nothing that shows prejudice, nothing as such, was mentioned in the examination. So what I'm saying is that as a human, we erred. And judges or magistrate are not God. And the case reference, it seems that it is, in this one is also under section 21B. And the instant case is 21C. However, Your Lordship, this looks like a clerical mistake, Your Lordship. However, the markings, and after that it was sent to the FSL. If I may take Your Lordship kind attention to page number 76. And it was thereafter sent to the FSL. Description of the exhibits, it will show that it's marked as A1 to 5, B1 to 5, C1 to 5, D1 to 5. So it's all in tally with the markings from page number 65. Perusing page 66 alone, it might have shown some discrepancies, but then it is not when all the things are read together. Your Lordship, with regards to section, that is with regards to section 52, Your Lordship. And Your Lordship, with regards to section 42, Your Lordship has already pointed out that it's a chance recovery and section 42 is not attracted. And Your Lordship, in that regard, I will place the reliance on this also, that that when there is substantial compliance of section 42, when there is substantial compliance of 42, then the whole trial cannot be vitiated just because of that. And Your Lordship, my learned friend have shown that information what in writing was sent to the by the seizing officer and reported the same. However, it was not countersigned by the officer in charge. However, Your Lordship, if I may take Your Lordship kind attention to page number 57 of the paper book. Though his information was not countersigned, this letter speaks for itself, Your Lordship. This was exhibited at Exhibit P2, page 57. And this was On receiving the information, this letter was written by me also. And Your Lordship, the third ground that my learned friend have taken is that this article was not produced before the court. However, Your Lordship, if I may take Your Lordship kind attention to the examination of the case IO, page number 15, 1 5 of the paper book. Fifth paragraph.
Yes.
Seized articles were produced before CJM Champai on dated 23/2/2021,
Yes.
which is intact in the cross-examination. And the picture speaks for itself at page 86 also, Your Lordship. Page 86 of the paper book.
Yes, after page 15, where you have come to?
Paragraph 5.
Yes,
The
paragraph 5 I have seen, yes. After that,
Page 86.
86.
86 is part of the exhibit, yes. In page 86, the photographs will show the JMFC sitting with the accused and the seized articles that was produced before the court.
Yes.
And the last point that my learned friend have raised is the place of recovery. But Your Lordship, it is a settled fact that it was recovered on between the front and rear seat in the black politic. So that is consistent. And Your Lordship, with regards to section 52, 50. 4 and 42, what I would like to state is that cannot vitiate the trust. I will place my reliance, I will mark my the paragraph that I would like to refer, Your Lordship. I would like to place reliance on NCB versus Kashif, and this is a very recent judgment which is not yet it was rendered on 12 August 2000.
This is regarding 42.
42 and 52. And Your Lordship, though there is no authoritative power in the High Court of Chhattisgarh judgment, I will rely on this just for reference, Your Lordship. And I will mark it, Your Lordship, give it to the court officer. I will just mark the.
What about other? I think he had 2 other 55 safe custody, go down receipt and all.
Yeah, Your Lordship, though the Malkhana register was not exhibited before the court. However, we can see that, Your Lordship, from the property search and seizure, it was kept in Malkhana. If I may take Your Lordship kind attention to page number 58. Page 58. This was exhibited property search and seizure form. 8. Para 8. Action taken and valuable property. Malkhana registration number 1 of 2021. NDPS Malkhana. It's written NDPS Malkhana. And Your Lordship.
Yes, page.
Page 58. This is exhibited P3. Exhibit
Yes.
P3.
Para.
8, Your Lordship. It's number 1 of 2021, NDPS Malkhana. And if I may take Your Lordship kind attention to page number 68. This is exhibit P10.
Page?
68. Captain and DPS Malkhana, column number 6. So what I would like to submit is that, Your Lordship, not producing the Malkhana register ipso facto will not vitiate the trial in otherwise approved prosecution case. Thank you, my son. Pen kalau holo kay kamar say lang pen kalau kanya.
Let's see.
Just a moment. Yes.
Let's see. May I have one small submission to review the submission made by the learned PP regarding the marks and numbers, my lords, which is at page 65. That is the inventory. As per the inventory, my lords, there are 4 boxes, only 4 boxes. But the marks and numbers, there are 20 marks and numbers. How many?
Page?
Page 65, my lords.
Yes.
My lords, as per this inventory, this is prepared according to the CIS article, which was even produced before the magistrate. So as per this inventory, only there are 4 boxes, that the tablets were kept in 4 boxes. But in the columns of marks and numbers, exhibit A1 to 5, so that is 20 marks and numbers has been given.
I'm not following. A1 to 5, B1 to 5,
Yes.
C1 to 5,
Yes.
D1 to 5.
Yes. So that is in
So
tally- yes.
five exhibits each in each of the 4 boxes. There are 4 boxes.
Yes.
Mode of packing.
Yes.
Kept inside black polythene and wrapped in 4 box
Correct.
with sellotape. So there are 4 boxes with 5 exhibits each. What is
So, my
the
lords, so as per the learned PP submission, my lords, which is at page 76 FSL report also. There are 20 number of exhibits, page 76, my lord. Page 76 and 77, my lord. There are 20 numbers of exhibits examined by the FSL. So at least 5 samples have to be drawn from each of the boxes. That is a very strange thing, my lord.
Your Lordship, there is nothing, no discrepancy. It was marked as A1 to 5, B1 to 5, C1 to 5, 1, 2, 3, 4, 5, A, B, C, D. D, 4 into 5 is 20, so.
Yes, there were total 20 exhibits.
20, yes.
Even in the these marks and numbers, 20 exhibits total.
Total, yes.
So FSL also received 20.
But it's very, very strange thing. There are four packets. And my lords, one small submission is that, my lords. So no witnesses, even the case IO, did not state during the trial that how many samples were drawn and the weight of the samples.
Yes, there is no description in the inventory as to how the sampling was done.
And my lords, so as per the FSL report, the memo number date 23/2. So that means so the sample were drawn on 23/2/2021. However, it was received on 1/3/2021. So during those whole period, who had kept the samples? So we cannot say that whether it was tampered with or not.
What is the FSL page number?
76.
Yes.
That is my humble submission, my lords.
So total recovery was 40,000 tablets.
Yes.
4 boxes means 10,000 tablets each. Divided into 5 exhibits, 1 to 5, 1 to 5. So 2,000 each exhibit. And FSL shows 2 tablets were from each. 2 and 1. 2 red tablets, 1 green tablet, like that from each exhibit. But there is no description of any drawing of samples, how it was done. Yes, and what was your last submission regarding where they were kept during the...
Yes, regarding section 55, custody of the sample, my lords.
Uh,
So as per the FSL report, it was sent on 23 February 2021, but it was received only on 1st of March 2021.
according to FSL report received on
1/3/2021.
0103
Yes.
21
Yes.
and sent on
23/2/2021.
where is that?
As per,
Where is that sending part? Date 23 to?
as per the FSL report at the first line, my lords.
All right. Okay.
So, my lords, in that regard, my humble submission is that, my lords. So, during those whole period, from 23 to 2021, till it reached FSL, who had kept the sample. So, the FSL, no prosecution witnesses did not stated that what is the specimen seal affixed on the sample. And the FSL report also did not disclose that the specimen seal affixed on the sample. So the sample and the sample seal, who had kept it during those whole period. So it cannot be said that it was not tampered with at all, because no prosecution witnesses stated it about the weight of the samples also, my lords.
No, what is the submission regarding this seal? You said something about seal?
Sorry, my lords?
About the seals, you said something. Specimen seal.
Yes, specimen seal, my lords.
Yes, what
So
about
whether the officer in charge seal was affixed on the sample or not. So there is no indication, no prosecution witnesses has stated about it, my lords. What kind of sample has been used for sealing the sample?
Yes.
That is my humble submission, my lords.
I fix this. Keep the judgments together. Okay, reserved.